doing this panel at a time when everyone is like, wants to be drinking coffee or taking a nap. So we promise we will move along at a good clip. My name is Rachel Geman. I'm in the New York office of Lieff, Cabraser. I think this is the only panel today that has only plaintiff speakers on it, although the crypto one had a good mix too. So that's, yeah.
Good afternoon, everyone. My name is Matthew Berman. I'm also a plaintiff's class action lawyer. I also do employment and housing class action work. I'm at the law firm of Valli, Kane, and Vagnini, which is a Garden City-based law firm. It's a pleasure to be here with you all today.
So we are here to talk about gender-based discrimination and pay inequality, although obviously pay inequity pervades across many different communities of people, not just women. We wanted to start with the legislative landscape because this is an area where actually there's been a lot of really good developments at the state level over the past few years in the wake of, both in the wake of Me Too, but also in the wake of increased emphasis on pay equality by everybody ranging from public interest groups to shareholders who have put a lot of emphasis on this. Perhaps one of the most successful initiatives across many states is that you're not supposed to use salary history in hiring for the obvious reason that that can simply re-up past inequalities or market-based inequalities where you have two people doing the same job but wildly different payments. So I would say that about something like 17 states have passed legislation prohibiting or modifying the use of salary history, and there's bills that have been introduced in many places. Another culprit of pay inequality and another area that's really ripe for legislation is salary transparency. I suspect a lot of us in this room work in jobs or for companies where there's perhaps less transparency than we would like, so it's always a funny thing to talk about, but the truth is it is now the law in many places that certainly applicants to jobs are supposed to have access to, if not automatic, be provided with pay ranges and so on. And a couple states even really want to do this sort of data reporting on a more aggregate level. And I should tell you guys too that this landscape is changing quickly enough that I had like a nice little sheet from 2018. And I was like, wow, this is already completely outdated. So the National Women's Law Center has very user-friendly maps for all these issues. No pay secrecy is a big recent legislative initiative where employees cannot be penalized for talking about their pay with other employees. How the hell is someone supposed to know if they're being underpaid if they don't have access to any information? The classic Ledbetter situation. That has been, about half the states have laws protecting employees from being penalized for talking about pay. And like we said in the beginning about this, what we consider on the plaintiff side at least, and really what a lot of people consider positive developments is not limited to women. There's sort of a funky history where the Equal Pay Act, which is a federal statute, is actually older than Title VII. It came about in 1983, not because the world was so progressive in 1963, excuse me, because there was a concern that that women had brought the wages down when they entered the workforce. And so the idea was, let's protect men. Let's make sure that men, as the breadwinners, don't have their wages undercut by women if we're stuck with women entering the workforce. So the Equal Pay Act was passed. And then a year later, Title VII was passed, which also prohibits discrimination in compensation. And those two statutes have sort of an interesting history, but as you may know, there's very little legislative history on gender in Title VII. And something to keep in mind too, like, so you could say, well, so why so much of a focus now on equal pay? I think originally pay would follow promotions or jobs a little bit more seamlessly, and so you could really focus on hiring and performance and so on, but pay is really important stuff. I just want to say a yes, but is that you could say we're having all these great things happening, but from the plaintiff's perspective, the fact of arbitration is still like you have like all these amazing things happening, and then arbitration is almost like counterbalances them, because until people can really bring law, you know, I almost feel obliged to say this, but it's just, you know, it's been a battle for such a long time. I'd almost rather have no arbitration and fewer of these laws, but obviously nothing is up to me. So I don't know if you wanted to add anything about the legislative.
Sure, sure. So, you know, the amazing thing is, you know, when we first started seeing Equal Pay Acts, you know, Equal Pay Act cases and wage discrimination cases, they were in the lower paid jobs. But now, as the workforce is more and more democratized, women are rising their way through the professional ranks, the investment ranks. We're having Me Too moments in different sectors of the economy, right? Look at the women's soccer team that we just had. Hey, that's the Me Too call out for this year, right? But before that, we had a case called POW, where executives are entering the workforce and they want to make sure that they're paid fairly. It started with women. It's now expanded to other groups of oppressed people, quote unquote. But, you know, you have other different protected classes. It could be race, it could be gender, it could be disability, it could be age. The law is changing very rapidly, very, very rapidly, and it is dog eat dog out there. It is sue or be sued, because if you're in any kind of institution with any kind of size to it, you're going to be on one side of this case or the other side of this case, and it's coming to you quickly. Why is that? Because the law has changed. When the law first started, you have to prove equal pay and equal work. I'm not being paid equally and I'm doing the same job. You don't have to show that anymore. You only have to show that your job is substantially similar. What's substantially similar? There's areas of overlap between certain jobs, and if there's enough of them, that could be sufficient for a court to find that there's liability for gender discrimination in pay. We started with the Equal Pay Act, but we've also got Title VII, and the law is changing so rapidly on this. You know, both of us have cases where, you know, we can see the impact on a recent, you know, case-by-case basis of what's happening. My firm just had a case a couple years ago, 2 years ago, Systemax, and we brought the case alleging equal pay violations and Title VII violations. The court there said, you actually don't have to prove it's the same job, you don't have to prove it's equal work, substantially similar is enough. And in that case, like a lot of your companies that you're either suing or defending are going to be in the same boat. They were using third-party compensation benchmarks to establish pay. So a reasonable person would say, isn't that how you're supposed to do it? Well, yes and no. It's a good place to start, but you have to make sure that your system is being applied evenly, uniformly, and fairly. You can't put women on the low end of the range of compensation for a position and put all the men at the high end. That's gender-based discrimination. So that's an example of a case, and you want to talk about one of your cases?
Sure. So, and I think we just wanted to be really mindful of who this audience is. I think everybody in this audience, or I don't know if everybody, but I suspect many people in this audience work for companies that are pay-for-performance companies, right? That are certainly ostensibly very meritocratic companies that really want to incentivize people and to give good performance. And I just wanted to talk a little bit about how performance arises in these pay cases. Occasionally we'll see a case, and my firm's Goldman's long-running case against Goldman Sachs is an example where we were able to demonstrate that there was discrimination in the application of the performance evaluation system. So in other words, women did not do as well as men under certain measures of performance, but we were able to show that there was discrimination in that through the use of statistics and other methods. Goldman has this complicated system where they had a 360 review that fed into a quartiling system and so on. If you are able to show that there is discrimination in the performance evaluation system, and you can sort of show that ineluctably that leads to disparate pay, then that is in some ways a very tight claim. It doesn't explain all the pay difference, but it can explain some. What you see just as what we see, at least what I see in my practice just as often, is that women do the same or better in the performance system, and yet they're paid less. And in a post sort of Walmart v. Duke's world, some companies, you get the sense that they're almost excited. They're like, well, we can't explain it. And you're like, no, that's not good. I understand it can seem at the moment like a really good defense to class certification. But the truth is that if you have a system where you're a pay-for-performance company and pay and performance are decoupled, that is not a good fact. And I should also note that there you got to really look at what is causing that to happen. Is it that there's sort of an ostensible performance system, but there's real performance measures that are not being shared with the employees? Are the criteria used for setting pay, are they valid? Have they been validated? Are they reliable? Is there appropriate training of the people making pay decisions? Is there bias by the people making pay decisions? The point is that defense folks should know that we as the plaintiffs' lawyers we will look at that. We'll look at in a pay-for-performance company, we will look at the performance, and we will see what happens there. And it goes to show that let's talk for a second about statistics. I mean, I don't think anyone at 4:30 wants to talk a lot about statistics, and there's probably a lot of very quantitatively sophisticated people in this room, but just if you're sort of interested in this, the kinds of statistical issues that arise in equal pay cases are the same that tend to arise in other discrimination cases and across others. Defendants will often say we're aggregating too much. The plaintiffs say, no, you can't turn people into tiny little groups. You're disaggregating, you're losing statistical power. Defendants will say, well, you can't compare this business unit where people sell like South American bonds with this business unit where people sell South American bonds plus one country in Central America, and we will say that, like, don't confuse your marketing with the reality that people are doing similar work. We could sort of go on and on, but the point is that there can be discrimination both when women, we're using women in this panel, but it could substitute in any protected group, are discriminated against in the performance system or do just fine, but then when the rubber hits the road, that's when it really matters. And we have a little performance ratings or so last year. A lot of Gen Z and a lot of people, and it's very human. Nobody likes to be reviewed, right? Nobody's a number. It's like you're a 2 in this criteria, you're a 3 in this criteria. That sucks. Nobody likes it, and so you can see why companies would want to jettison formal performance reviews in favor of ongoing feedback or something that makes it easier for a person can't really do something with feedback like you're a 3. You theoretically should be able to do something with feedback that's very precise, that says, well, sometimes when you do this, blah, blah, blah. So it's not like we on the plaintiff's bar are like, let's bring back draconian performance reviews where people are, sat in a room and told they're terrible or whatever. But we do have to be mindful of the fact that oftentimes there is a performance review system, whether it's explicit or not, whether it's shared with the employees or not. There is a system wherein somebody decides who gives the good opportunities, who gives the good assignments, and so on. And so it'll be an interesting ongoing issue as there's a very understandable desire for qualitative feedback against the backdrop that people are paid in paper performance companies based on reported differences in performance. So it's an interesting sort of tension.
Sure. So tying into that sort of theme, generally speaking, when you work for a company, the easiest way to get paid the most is to tie your work directly to the revenue of the company. The closer you are to the source of revenue coming into a company, the stronger your claim is for a piece of that pie. The further away you are from the revenue coming into the company, the more attenuated your claim is. So we all know as a result that you have many different kinds of positions that are supporting revenue of a company or maybe even reducing the expenses of a company. They're not compensated the same way. It becomes more and more difficult to engage in performance reviews for people who are further away from the source of revenue of the company. What does that lead to? It leads to performance reviews that have to serve conflicting purposes within the same environment. On the one hand, if the employee is performing at least adequately or above, then nobody wants to rock the boat too hard and to damage the relationship between the company and the employee by being overly critical of them. On the other hand, if you've got an employee who you have your doubts about, you could end up in a problem where you want to get rid of them, and now they've got these favorable performance reviews, and you're laying the groundwork for an employment litigation.
Or no reviews, right?
Right.
Yeah.
And that's actually something that we see a lot, especially in municipal government. We see employees who have not had job reviews for year after year after year, because in that kind of environment, you only get reviews when they want to paper the file to promote you. Just like you only see negative reviews when they want to paper the file to get rid of you. We have to have an understanding of what the review animal is, and it serves conflicting masters and conflicting purposes. And that leads to a situation of garbage in, garbage out. If you have a situation where you don't have objective criteria for reviewing employees and for judging their performance, then you don't have objective criteria for setting compensation either. And that's part of the way that we get to pay inequality in the workforce. It's really a function or a combination of two factors. On the one hand, lack of transparency. How do I know if I'm being paid fairly if I don't know what other people are being paid? That's the first prong. The second prong is lack of objective factors in establishing compensation. And when you mix those two together, you get a recipe for a problem. And the more people you have doing the same kind of job in the same kind of environment, the more room there is for us to get under the tent and say, you've got a class action. All your X are being paid less than all your Y.
Exactly. And I think that's good advice about transparency and thinking about the criteria. I mean, I would add, and frankly, I'm gonna read a list of things that companies can do that has like almost total Venn overlap with what a defense lawyer said in a conference recently. Like these are not. It's hard to argue with some of these suggestions. I think if people are concerned about equal pay in their workforce, it's imperative to conduct regular and robust pay analyses. A lot of times people's shareholders want those anyway. It can be very tempting to say, well, we've done our own analysis and men and women are paid the same. Keep in mind someone, savvy investors or plaintiffs lawyers will look at that and say, how did you get that? How did those statistics work? So I think regular, and defense lawyers will often say, well, the answer to that problem is to make sure everything is shrouded in privilege, otherwise it's just too risky. A rejoinder from plaintiffs folks is, yes, it's a bit of a delicate balance, but if you keep you don't want to shroud the entire HR function in privilege, because then the people actually making the decisions don't have anything to work with. Matt talked a little bit about the importance of objective criteria. I would add to that it's in addition to being objective, they really have to be validated and related to the job. It can, I don't want to say it's easy, but somebody can make a list of things that a job is supposed to entail that sounds good, but you really want to kind of push further to say, what are the actual criteria for this job? What are people doing? How do we measure those criteria? Is it a vague, is there something that sort of sounds good, but might in practice be really vague, like potential? You could say, well, wait a minute, I'm a company and I need to find, I would like to hire future leaders from within the company. I don't want to always go outside. Of course I want to look at the potential of my lower level employees. That can be right, but don't use potential to do past performance. Potential can be very vague. Really look more specifically, potential for what? If what you're saying is, does this person show that they are able to be educated to do the specific task of the next level job? Kind of say that instead. There can be evaluations of starting pay, especially, and leveling, which is how did we get to where we were with starting pay? And a lot of times employers will be like, well, because all these folks were hired like 3 years ago and now we're unleveled. It's like, you can level people. and I know it can feel risky to an employer because once you say that there's been unleveling, it seems like it's inviting a lawsuit. But obviously some of the sting is taken out of that when you've done proper leveling. Having really good internal investigations is important, as opposed to people feeling, and people feeling chilled from reporting to HR, or people feeling like it's just going to be a perfunctory investigation where everybody already knows the outcome. It's not an easy thing. It's hard to investigate oneself, and but it is sort of a hallmark of good HR. And I think too that, and we were talking about there is this relationship with other types of hiring and personnel practices. So making sure people are paid fairly on hire, making sure the performance system is fair, looking at their promotions to make sure it's not just some sort of vague tap on the shoulder. I mean, it's a lot of work, but it really is worth it. And I think that just the mere existence of committees with sort of terrific and progressive sounding names or sort of external awards, those really aren't as, unsurprisingly, they're just not as, they don't really move the ball forward. And then I think we were supposed to talk a little bit about AI in this panel. The Department of Labor and some other government agencies are looking at the use of AI in hiring, not so much as a pay system, but just how it can unwittingly, how machine learning can unfortunately create discrimination. Like a machine might say, on average, more men than women have, whatever, this particular type of engineering degree. And assuming for a second that particular type of engineering degree versus some other degree, like math or biology is needed for this job, then the computer might just say it's more efficient for me, the computer, just to look at the men. So you kind of got to be, the computer doesn't know that, but you kind of got to watch the AI. So yeah, it's a lot of work.
So I guess the question that I would have if I was an employer is, okay, what can I do to make sure that I don't get sued? That's number one question, or maybe even number one, how do I make sure that I'm doing it fairly? But of course also, how do I make sure I'm not sued? You could think about it in terms of what's the low-hanging fruit here. The low-hanging fruit is look and see who you have doing each job. Just do a simple sort of their total compensation at the end of every year. And take a look at the list. Are all the women clumping to the bottom? Are they interspersed from the bottom to the top? What kind of result are you seeing just at first blush? And then if you see something that raises a red flag, like all the women or all the minorities are clumping to the bottom of the compensation scale, you should do what's effectively an internal audit. Just internally, defend your choice. Why does Sally make less than Bill? What's the reason? I've done that exercise on the management side. A lot of times there are good answers. A lot of times the answer is, I don't know. And if you don't know, that's where the problems are. It's not ideally you look at it and say, well, it's years of experience, or it's a degree, or it's a this or that. It's some objective criteria. In the old days, great, that would be enough. And if you don't know the answer, then even it out, right? That's the easy solution. But today, that's not even a solution, because again, it's not just any defense, any objective factor that's going to be a defense. It's only legitimate business factors that are going to be a defense. Well, it's not enough to say, well, Bill has an extra 2 years of education compared to Sally, unless that ties into the job they're doing. And it gives you some kind of work-related result. You can't just pick criteria out of the hat. They have to match the job you're doing. That's number one. Number two, how do you know who to compare? Well, obviously someone in the same job title, that's the easy place to start. And then typically in a large enough organization, you'll see they'll have, for example, business analyst level 1, and business analyst level 2, and business analyst level 3. Most of the time, that's the same job. Or it's sufficiently similar that we're going to have a good argument if we start comparing those people as a group. So be on the lookout for that. If your organization is large enough and you can justify the expense, hire an industrial organizational psychologist. Okay? There are people out there that have the entire science of how you compare one job to another. How do we know what criteria or what skills, what knowledge, what abilities are necessary to do this job, go get professional help, because those are the people we're going to be calling as experts in our cases, saying there's an 80 or 90% overlap between these two jobs, yet people in Group A are mostly African American and they're all paid less than people, than Group B, that's just mostly white. And in fact, the situation is so crazy now that the white men are suing for pay inequality. And here's what's happening. We have a case now against the fire department of the city of New York. Our clients are mostly African American. They're mostly paid a lot less than building inspectors in the Department of Buildings who are making more money for the same job. But guess what? Even in the underpaid group, there are white men in that group, and they're saying, we're paid less too, because we're mixed in with the mostly African Americans. So everybody is affected by this. Everybody's going to be on one side of the V in a litigation if this continues on. We're just going to, because this is where the money is.
Yeah, no, I think that, and I think this ties in perfectly to this question of occupational segregation. Sorry, I might not.
Oh, thanks.
Okay.
No one ever said I'm too quiet.
I mean, no doubt there's always the person that if you sort of at a cocktail party or at coffee or whatever on the internet, you quote the statistics that African Americans make X for every dollar that white people make, or women make X for every dollar. Somebody always says, well, yeah, maybe, but people do different kinds of jobs, and isn't there an element of choice, and that's not really rigorous, or maybe that addresses other problems, but it just can't be true that women make 70 cents for if a man and a woman are both flipping burgers at McDonald's, it can't be that the woman is paid 0.7 of X. Yeah, if two people are flipping burgers at McDonald's, then that's probably true. But nor is it the case that but both things are true. Occupational segregation is real. It's also true that even when you look at within a company at jobs that are very similar, those aren't. If you have the business analyst example, business analyst 1. That could be just a basic pay case having nothing to do with occupational segregation. The defendant might say that business analyst 1 is actually 30,000 different jobs. And then you really, as the plaintiff's lawyer, have to be like, come on, this is an entry, this might be a post-college job where everybody basically does the same thing. People rotate and move around. They're all trained the same, and they all move up the same way. So just to be clear, there's an element of thinking about what could be called lower, colloquially occupational segregation that really isn't. It's really not different jobs. It's just very, very similar jobs that have just different titles. But it is also worth spending a little bit of time talking, as Matt started to talk about, is how occupational segregation does come up in our cases, and just the fact that sort of we all know that titles are not enough to say that jobs are different, but what if you go a level below that, and not just the titles, but the jobs are described as being quite different? How do you really know when they're essentially comparable, which I think is
that's where we tie in with the industrial organizational psychology. There's a whole field of science out there of comparing jobs. Do they look at the job descriptions? Yes. Depending upon what type of job it is, there may be application criteria, there may be career progression that they can track. They may actually go out into the field and follow people performing the job and record how they spend their time, what they're spending their time on. So there's this science out there that will allow you to compare jobs. And the key takeaway is jobs don't have to be the same to create a pay discrimination lawsuit. And the numbers are getting bigger and bigger because we're talking about as time goes by, jobs that are higher up in the economy. We're talking about consultants, we're talking about bankers, we're talking about lawyers, all the people that, in the beginning were afraid to speak up for themselves because they're one person breaking into a profession. I'm the only woman. I'm not going to rock the boat harder than I have to speak up. But as time goes by and more people enter the profession, more and more people are seeing that things are not working properly, and they're talking to each other and they're comparing notes. And so you might think you don't have transparency, they're never going to find out. People are going to find out because pay is so important to them. We talked a little bit about how we have pay transparency laws state by state.
But there's also federal law that applies to this, because under the National Labor Relations Act, employees are allowed and they're protected when they're talking about the terms and conditions of their employment. You might not like it, but if they're in the lunchroom comparing salaries, that's protected. And so people are going to find out. And so the question really ought to be changing to, how do we design a system that satisfies the business need while not creating legal liability, right? And that's where objective criteria come into play. You can't, because if you just let it alone, managers will exercise their discretion. They're going to have their favorites. They're going to give more to their favorites or to people who they think are going to support them in advancing their own careers. And that's going to create liability for the company. So increased transparency, increased objectivity eliminates a huge part of the problem. And then tie that out on the other end with annual pay reviews where you internally look at your compensation and assess whether there's vulnerability. I personally recommend you use outside counsel for that, because it's very difficult for the internal people to look at it in an unbiased way, because they're naturally going to tend to the point of having to defend their own compensation decisions. You don't want to put people into a position where they have to defend what they've done. It's better to put them in a position where they say, I've done what I think is appropriate, and now it's time for expert review. And then they can tweak it from there. That's what I recommend. It'll go a long way to reducing liabilities. And also, keep in mind, an ounce of prevention is a pound of cure. And even if there is a problem, it's better that you fix it now. We have something called the continuing violation theory. So if we bring a case under New York City law or New York State law, we can go back in time to the time where we first set the compensation and say that every year since then, the discrimination has continued, and the statute of limitations does not prevent us from going back in time to, let's say, 2006, now in 2023. So a $10,000 a year pay disparity over 100 people over 16 years with 9% prejudgment interest rate is compounding at, it's not compounding, it's simple interest, but it's growing at a very quick rate, and it's going to be big numbers very quickly, which is why plaintiffs' lawyers are going to increasingly focus on it, and we're pushing the envelope. We've now got associational discrimination claims, where we've got white people saying, as a result of our association with an affected group, they're in the pot too. They're suing also. And with changes to the law now, the door is open to punitive damages. The door is open to emotional distress damages. Those used to be unthinkable to obtain in this kind of a case, but all of that is on the table now. If you're in a position where you're a big enough company and you ought to have known better, and people bring things to your attention, and you ignore them, you push them aside, or maybe your lower tier people push them aside and don't escalate the problem, if it's documented in the record somewhere, it's going to come out and it's going to bite you. I really recommend getting ahead of it. Or don't, so we can sue you.
No, get ahead of it. We'd almost rather not. We can do other cases. We'd rather the pay was equal. So we wanted to, and then, Matt was talking a little bit about different kinds of remedies in these cases, and folks probably know that under federal anti-discrimination law, the types of remedies depend a little bit on whether it's a so-called intentional discrimination claim versus a disparate impact claim. The EPA, the federal EPA itself, does not have a sort of knowledge or willful requirement. The state laws tend to do it differently. The basic upshot is that if you're not doing something on purpose, that's better. There's always really interesting questions in this day and age of what does purposeful discrimination look like? What does purposeful discrimination look like when you have lots and lots and lots of different managers, many of whom might be women or people of color or what have you, effectuating common decisions? These are complicated questions. I mean, intentional discrimination does not require that you have this willful sort of hatred or misogyny. Having said that, when there is evidence of bias by the decision makers, that is relevant. If the person, you know, notwithstanding all the rules, and Matt, I agree with what Matt said. People do chat about pay. They chat about pay to an extent. People are often a little sheepish, a little embarrassed, and so somebody might not know when they're being paid less, but they certainly know if they're being, you know, subject to horrific, however glib and fun comments or you know, or harassment. So if we're looking at, you know, it's not like these cases are totally separated from other types of discrimination. If there's, you know, like getting back to the System X case, which was Matt's case, it's helpful for class action lawyers too, not only for this notion of how do you find a comparator in pay, but this question of what's the relevance of bias of a decision maker. If the claim is a pay claim, not a harassment claim, is the bias of the decision maker relevant? Yes. So, you know, we want to just be clear that although we're sitting here talking about equal pay, it's not like this is sort of its own unique, discrete thing separated from the rest of the workforce and the company cultures. The company cultures are really important. And it's funny, Matt also mentioned discretion, and that's certainly true that a lot of more sophisticated pay-for-performance companies are it's very important to them. You know, we're not a widget machine. We empower our people. We foster creativity and so on. And theoretically that is, people do want to be given their wings, but there are ways to ensure that discretion is appropriately cabined. I mean, you can do training to common behavioral standards. You can show people what a certain criteria is supposed to look like. If you're evaluating people based on, you know, business acumen, you got to show people what that looks like, because people are really good at picking out stars, and people are really good at picking out disastrous employees, but the messy middle is really hard. So you gotta help your employees along. So anyway, that's sort of a hodgepodge of comments, but we don't want to make it sound like this pay issue exists sort of outside of the other issues of discrimination that, as well as attempts to deal with discrimination that can pervade the workforce.
I think that's right, but I would also add that both of these kinds of claims, class action claims and individual discrimination claims, are sort of trending in the same direction. They're not there yet, but they're trending towards almost a form of strict liability. And what I mean by that is that under both city law and state law in New York State, you don't have to show willful discrimination. You don't have to show intentional discrimination. There doesn't have to be any conscious intent involved in that process at all. It is sufficient under city and state law to show that members of the protected category are treated less well than the people outside the protected category. And System X goes further than that, because System X says you don't even have to compare yourself to anybody. You could compare yourself to yourself of a different gender. Because in System X, what was happening was you had department heads. You had a female department head and you had male department heads. I think this is very interesting. So during the plaintiff's deposition in that case, they asked her, well, you're the head of risk management and you're comparing yourself to the head of, for example, internal audit. Can you do his job? No. Can he do your job? No. So they're not the same job, okay? And the defendant moved for summary judgment on the basis of that testimony. But the Second Circuit, in ruling on an appeal on the summary judgment decision, determined that Lindsay didn't have to show that she was doing the same job as the other department heads. Lindsay was the plaintiff in the case. The judge there said, what's happening in this case is the defendant is saying that it's using compensation benchmarking, that it's getting from outside third parties to establish compensation. But Lindsay's allegation is that she was put at the low end of the benchmark for her position, and the men were marked at the high end of their benchmarks for their position. And if she's able to prove that, that's a sufficient claim under Title VII, and there were also analogous claims under state and city law. And the court went further and said she doesn't have to have any comparator, because what she's really arguing is that if she was a man, she would have been at the higher end of the range, and she's a woman, so they put her at the lower end of the range. So she's really comparing herself to herself, but because of sex is based on where they put her at the end of the range. So System X is really a fascinating case as far as that goes.
Yeah, I would agree, although I do think that, I mean, from the sort of very arid outside perspective, that wasn't my case. I think the fact that the plaintiff, and you guys did a good job developing that reality, that evidence of bias in the decision maker, because that can be a real tough case otherwise. I mean, you know, there's a lot of, when these laws were made, Matt talked a little bit earlier on how the exceptions or the exemptions have tightened appropriately. Like, you can't just point to any marketplace issue. You can't say, well, you know, it's not a fair market, so we can pay women less. You can't say, well, the incoming female and male had differential salaries, so we can pay them less. It is under federal law. There are these. They're not so much exceptions, but there's language that talks about if payment is made pursuant to a bona fide seniority or merit or quantitative system, then it's looked at a little differently. We found there was a time when defendants were really, about 10 years ago, when defendants were really trying to run with that. You know, they were saying essentially like a financial advisor job is sort of akin to like making widgets. You know what I mean? Like, we have, it was a quantitative production system, and that got pushed back. But just, you know, just keep in mind that the defendants, I mean, we all know this, but on the plaintiff side, the defense side, nobody's going to sort of roll over and say, yes, we choose to pay, you know, people of color less, we choose to pay women less. There's always some reason given, and it's just good to be mindful of what sometimes worked in the past. And sometimes it's the defendant citing essentially old law, but you know, these are important cases, but they can be tough cases.
I love the financial advisor example that you just raised, because that ties together so many different issues for me. Because you know, under Equal Pay Act, the traditional defense is, well, you can point to a factor other than gender as the basis for your, you know, pay differential. That's how we started, but that doesn't work anymore, because as we've now learned, the factor other than gender has to be relevant to the job that's being done. It has to basically be serving a legitimate business necessity. It can't just be some willy-nilly factor. If education ties into the job and the performance of the job tightly enough, then you can use education. But for a job where it doesn't do that, you can't rely on education. So the fact pattern matters. And I love the financial advisor job example, because that's an example where quantitative production can be measured. Because financial advisors typically earn commissions on how many trades or trade volume or whatever it may be. But there's an embedded question in that, which is, how do they get the clients? If you're steering all the crappy clients to the women and to the minorities, and they're not getting an equal selection of quality clients, then you're embedding into the you know, quantitative production some subjective factor that's discriminatory. And there was a case on that too. That was Turnley versus Bank of America. It was a racial steering case involving financial advisors, and it was a multi-million-dollar result.
Yeah, and
then Bernstein Lewis.
Right, and then we had, I mean, I argued the 403 issues also against Bank of America Merrill Lynch. It arose in our Calabuso case, so it sort of had its moment. Those 703 arguments, and even if those I mean, we don't see defendants so much now arguing that, because, you know, our case and others kind of created some better case law, but you know, so certainly defendants will say, well, we might have a seniority system or a merit system, so it's good to.
But it's also like, where did that come from, right? All this came from the manufacturing environment, the industrial environment of like the 50s and the 60s. So they could say, for example, if you're making 10 widgets an hour and she's making 8 widgets an hour, then it's reasonable that we pay you extra for the 2 widgets. But that example only carries so far. In the modern workforce, where we're not just goods being produced, we're also largely a service economy. How does it translate? It doesn't translate exactly the same way. And so the courts are really scrutinizing these factors other than gender, and they're saying, okay, that's a factor, but does it tie into the nature of the work being performed, and is it bona fide? You know, where's this criteria coming from?
Yeah.
It's fascinating.
Right, and it arose too out of, you know, people were really, really scared that people who had, you know, white men largely, who had sort of worked for all this time, that they would lose their privileged position in their union back in the days when people had, to find benefit. Not everybody of us knows what that is. You don't have to. It doesn't have to be a 401k. You can get like a set amount of money, which nobody really does anymore. Okay, should we? Do you want to go on to the next slide? Yeah,
We're open up for questions.
Yeah,
Whatever you think. I don't know how we're doing on time, Dave.
We should have.
It's fine.
Yeah, 15 minutes.
Okay, go ahead.
Do you all have any? Oh. You're a genius. I forgot that was there.
So we have the ability to open up for questions or comments about any of these materials, or I could, if you want to see something interesting,
Oh yeah,
you could maybe show. I don't know. Is it part of the same slide deck, or do we need to switch to the other slide deck, David, to show
Change.
the other material?
Do folks have any questions? Well, we'll show you some cool slides.
We'll show you something cool. Yeah, if we can bring it up. There we go. I see it, but it's not on the screen. There we go. All right, guys. So, in preparing for today, I put together a little trinket for you. This is basically a quick little slideshow about gender-based discrimination and pay equity. This sort of recaps a lot of the points that we talked about today. On the left, you have the women's soccer team, so they're sort of like the poster women for pay equity in the sports context for the last year. And we added an animated GIF just to spice it up. And we can go on to the next slide, please. Or do I just hit the one here? Okay. So then we've got what is gender-based discrimination? It's basically when you pay somebody less for substantially similar work. Why does it occur? Because of lack of transparency and too much discretion in setting compensation. Who does it affect?
And use of invalid, and the use of invalid criteria in setting these things. I think it's just
lack of bona fide objective criteria.
Exactly.
I think that's how we could synthesize that.
Yeah.
Then this is a timeline of some of the relevant, impactful developments in equal pay. 2021 on the top, that's the Chalmers Fire Department case we talked about. 2019 is the Lindsay versus Systemax case we talked about. You can see the takeaway.
Sort of sheepish that all 4 cases up are one of our 2 firms.
Yeah, it's just
it's actually
self-promotion. That's
yeah,
fine.
this is pretty ridiculous, but yes, these are important. These are not the
If we can scroll up, I don't know, is there a way, David, to scroll down on that, where you go, call to action is the end, I don't know. If you can scroll up to the timeline, and then it's actually like a multi-page slide, I don't know if that's demonstrable. That's the last slide right now.
I think you need to go back.
Okay. Yeah, here we go. No, multiple timelines here. Okay, yeah. So anyway, the gist of it is, this slide actually extends down a little further. Case number 3 in 2017. That's Rachel's firm's case, right? And this case also is actually important because it ties into what the scholarship on executive compensation has found out in terms of how compensation is set and how courts are basically loath in the business context to second guess a business decision about how compensation is set. And the result of that is a lot of pay discrimination cases historically got thrown out and they were given short shrift by the courts, but the pendulum is swinging back the other way. Here we've got the Chen Oster versus Goldman Sachs case that Rachel spoke about earlier on. We've got the Lilly Ledbetter Fair Pay Act, which was in response to a horrible decision in the courts, which basically said that you were discriminated against at the time when you get your paycheck, and if you discover it much later, too bad, so sad. This Lilly Ledbetter Fair Pay Act acknowledges that unlike other forms of discrimination, it's very difficult to know you've been discriminated against. How are you supposed to know what anyone else is getting paid compared to you? So you should have to take action based upon when you reasonably can discover that, not on when you got your paycheck 12 years ago. How are you going to know? And then tracing it back to the Equal Pay Act, which we talked about in 1963, the criteria for an Equal Pay Act claim is very strict, and now the pendulum has turned or flipped the other way around, and where we are now is you've got the Paycheck Fairness Act of 2019 opens the door to punitive damages, mental distress damages, and it makes it easier to get opt-ins for your class certification. That's another benefit. Then on the top left panel there, you've got the New York State Equal Pay Act. which is codified as New York Labor Law, Section 194, and you've got a comparable statute in California. These laws require substantially similar work, not equal work, which means it's way easier for plaintiffs to prevail in their case. Those women that you saw on the first slide, they got $24 million worth of back pay. The Google tech women got $118 million. The cases are getting larger and larger and larger. Our fire department case has roughly $90 million in alleged damages. We're investigating another one right now. It's about $300 million in damages. They're just going to grow and grow and grow as women are paid more and more and more. The differences in pay are going to grow and grow over a longer period of time. The numbers become staggering. Oh, our first question.
I feel like I've asked a lot of questions today. I'm curious to know, I don't have a lot of information about how it is on a state-by-state basis, but I know, because I'm in New York, that New York recently passed a law that requires salary ranges to be posted on job offerings. So I'm curious if it's too soon, or have you seen any effect of what, of that ruling, of that law, on the practical implications of women bringing, or anybody bringing discrimination?
I don't know if there's you may know in New York, but I think the National Women's Law Center, it's an excellent question. There's some general research about the benefit of similar laws like this, but the precise answer to your question is one that I don't have, but the National Women's Law Center would. I don't mean to pun, but I can say that when the bill was being sort of pitched to the New York State legislatures, I think there were packets that talked about that answered those sorts of questions. I think the simple answer is yes, it's helpful. I can't personally say that I've brought a case that I wouldn't have brought before based on this, but I really like seeing the job postings and seeing those salary ranges.
I'll give you my observations as well. I do agree that it's helpful. If you're job hunting, it helps you to see ranges. Observationally, employers are tending to flout the rule because they're using exceptionally broad pay ranges. Conceptually, it's easy to conceive of women being slotted into jobs at the lower end of the advertised ranges and men being slotted in higher. If that actually manifests, then one could envision a class action case being brought based upon common job postings for positions that turn over enough, significant enough incumbent population that the damages are significant enough to bring the case. But I would imagine it's going to take some time to get to that point.
Right. Although I will add this, which is that one thing that the research does show is that if, I'm sure we've all seen examples where, and obviously it's not every man and every woman, but if the employee has to negotiate for their salary, that disadvantages certain groups because you can be considered like pushy for doing that, so you're in this double bind. When people are given ranges, yes, they can be too broad, but there is some empirical data that when you are given ranges, it facilitates one's ability to negotiate. Because otherwise, you're like, I have literally no idea what to say. What's your salary expectation? What you want to negotiate from, and the sorts of data points are very helpful to. I think some of the research has been done with women, so it is this funny dialectical thing where even if the ranges are bigger than we'd like, it kind of does assist in other ways. So it's going to be probably good but subtle effects.
I'll also add that salary negotiations are a source of potential liability for employers because, first of all, the background of the Equal Pay Act was that from Congress's point of view, the market is failing. Women are not being compensated properly by the market. Therefore, Congress has to intervene and to establish this law that requires that people be paid comparable pay for comparable work, or for equal pay for equal work. But what we have seen is that it's not an excuse to pay someone less because they didn't bargain for more money. That's not a bona fide reason for the pay disparity. And we've actually had case law on that, not in this context necessarily, but there was a series of credit discrimination cases brought in the 90s. They were brought against all of the auto car finance companies, Toyota Motor Credit, GM, Acceptance Corp, etc. And those cases were about what people pay when they borrow money to finance a car. And what we saw in those cases is you could have people who come in at the same credit score and the black person was charged 18% and the white person was charged 14%. because the dealers had the discretion to quote whatever rate they wanted up into the maximum rate that would get approved for the loan. And so they exercised that discretion in basically what was a search for suckers. If they thought you were going to pay more, they would charge you more. If they thought you were going to pay less, they would charge you less. You walk in, you're well polished, you're wearing a suit, you drove in your own car, they're going to think you're more sophisticated, you're going to be comparison shopping, they're going to give you a better quote. If you roll in tattered clothes, you took public transportation to get there, they see you dropped off on the bus, or you come in like a 1980 beater car, they're going to ding you. And we brought those cases and we said that's pay discrimination in violation of the Equal Credit Opportunity Act, and the court said there's no bona fide part of setting the price of a car that's based on negotiation. That's not a defense to credit discrimination. The same principle applies here. If you can't...
Except that though, there was, I mean, yes, you know, both of our firms worked on those cases, but, you know, and this is just another issue with arbitration to sort of finish where we started. Like what we're seeing a lot of now, and we all know this, is that there's theoretically very good substantive laws. There's good case law under ECOA, there's good case law under the discrimination statutes we talked about, but the biggest issue is not so much with the substantive statutes, but with arbitration and the sort of early overly restrictive interpretations of Walmart v. Dukes that basically killed a whole bunch of those cases in 2011 that were analogous to the ECOA cases when the mortgage conference. Anyway, I think, well, any more questions? I think we're done. Okay, no, we don't want to.
We'll reserve our time for rebuttal.
Exactly.